That's your goodbye day, right? You should be, I know you're sad, I'm also sad, but that's the way it is. You need to go to term 2. So, chapters 15 and 16, by the way, just one more thing. Most of you, not all, but most of you know I'm writing final exams next week at UBC. I have law courses, I'm taking law courses at UBC. So I won't be here for my office hours unless I get an email from you. So if you email me saying, oh, I would like to see you or meet you, I will come. If I don't get an email, I won't be there because I'll be preparing for those final exams. Okay? But it's okay with me to be here. I just needed to take the initiative. Right? So send me an email. I would like to speak with you, solve some doubts, or have some questions, whatever the issues. I'll be here. Right, so what are we looking at today? First of all, it is priority of creditors, but not only this, we're actually talking about loans. We're talking about borrowing or lending transactions, and more specifically, secure transactions. So this is the topic for chapter 15, plus bankruptcy. We'll look at bankruptcy. And for chapter 16, we'll be looking at sales, legislation, sales contracts, and some consumer legislation. So, starting with chapter 15, and I know most of my lectures are a little bit boring, but I apologize, this should be a little bit more, because it's a very specific subject, a lot of details. So I'll try to convey what is most important to you, okay? So we start by saying, if my neighbor borrows 10,000 from me and promises to pay me this 10,000 in 1 month, in 6 months, in 1 year, and just promises, I will believe my neighbor's promise to pay me. And I have nothing else. Would you agree? So I give my neighbor 10,000, and I expect my neighbor lives up to their promise. But what we are looking now is we can have those transactions secured. So there may be a collateral, as we call it, or there may be a security that in case the debtor defaults, does not repay properly, the creditor can seize the security, can sell the security, and then recover some of the losses, or all the losses. So is this difference clear? One is just a promise. So you promise to repay 1,000 that you get from me. It's just a promise, and I hope you live up to this promise. But in the business world, promises are not enough. So companies, businesses, they usually have to offer something, either a real property or personal property, as security. Because if the repayment is defaulted, then this security is seized. So that's what I'm saying there. Both personal and real property, they may be used as security for loan transactions. Something that most of you know, or at least have heard about. Mortgages. What is a mortgage? You get money from the bank, and you offer the real property you are purchasing as a security. So the bank will seize the house you purchased in case you default the mortgage, sell the house, recover their losses, give you back the surplus, or charge you or try to get the money if there's still a balance. Okay? So that's basically what it is. So the first type of this secure transaction we look at is known as pledge. And what is a good example for pledge? The pawn shop, jewelry. So you have jewelry, You go to the pawn shop, you give your jewelry to the shop owner, and you get some money in exchange of this. You are not giving the title, property. You are just giving possession of your jewelry. Then you get the money. As long as you repay it properly, you regain possession of your collateral, of your jewelry. But if you default paying, then possession turns into property. And then the pawn shop owner may sell your jewelry and recover the loss. So this is known as pledge. Is this clear? There's only possession, no title. Title only upon default. Okay? Another one, and we've seen this already, conditional sales agreement. What is the conditional sale agreement? It is mostly for real property, not only, but mostly for real property. When the construction company is financially strong, they offer you to finance your real property purchase directly with them, not with a financial institution. So they give you possession, but they don't give you the title. You pay for the real property in 5 years, 10 years, could be 20 years. And then when you pay the last installment, title is transferred to you. Clear? So in this case, in pledge, for the jury, you have the title, you just gave possession. But here, you, the debtor, you have possession, but you don't have the title yet. You don't have the title, it means you cannot sell it, because it's not yours yet. Okay? And then upon the last payment, or payment of the last installment, then title is transferred. Clear? So that's the conditional sales agreement. A chattel or goods, we know they are synonyms. Chattel or goods mortgage. For example, for machines, this is widely used by companies. So what happens? We have three parties in here. We have the seller, the machine manufacturer, for example, the buyer, and the financial institution, which is the creditor. So as a buyer, I get money from the financial institution, and the financial institution, the creditor, pays the seller at site. They pay the full amount. And then they give me the possession as the buyer. So the buyer will have the possession, but the title will transfer from the seller to the creditor, to the financial institution. Okay? Similarly to what happens in a car leasing. When you lease a car, the leasing institution, the financial institution, will pay the car dealer the full amount. They will have the title of the car, and we, the buyers, we have the possession of the car. So that's the same for machinery, for the goods or chattel mortgage. Is this clear? My company needs the machinery, doesn't have enough assets to buy it, so gets money from a creditor. Creditor pays the full amount to the seller, but retain the title of it. I am the buyer, I only have the possession, so I can use it and repay the loan properly. If I don't repay, creditor has the title already, they will just regain possession, sell the machinery, try to recover the losses. Are we good so far? So those are loan transactions. We can also assign book of debts. So my company sells on credit. Let's say I have 20,000 of sales made already on credit. So buyers will pay in 30 days or 60 days, 90 days. So they are my receivables, right? You remember about this from econ? Did you see this in econ or maybe math? Well, but my company has receivables of 20,000, let's say, and I need money. So I go to the bank or any financial institution, I get the money, I borrow the money, and I transfer those receivables, those debts of my client to the financial institution. It means, when I'm transferring debt, it means that if I default payment, the financial institution may intercept those payments and they go directly to the financial institution. So again, it's another type of security. Okay? I can show my invoices. I've sold 20,000 on credit, so clients have to pay me in 30, 60, 90 days. And if I default, only if I default as the borrower, as the debtor, then the financial institution may intercept those payments. Clear? The other one is lease. So leasing, like leasing a car. This is simple and straightforward. Lease is like renting. So when we lease a car, for example, or most airline companies, they lease airplanes. They don't buy airplanes. So what happens? Similar to the chattel or goods mortgage. A financial institution, and for airplanes there may be more than one financial institution, they purchase the airplane, or the financial institution purchases the car for us, and we get the possession. So we are the lessee, and the financial institution is the lessor. The dealer, the airplane dealer, oh no, not the airplane manufacturer, or the car dealer, they get paid in full after the sale. And then the lessor, the financial institution, they keep the title of the goods. If the lessee, the buyers who lease the car or the airplanes, default on payment, again, the lessor, the financial institution, may regain possession, sell, and recover their losses. In other words, leasing is like renting, because we, the lessees, we are just paying for the use of that property, of that product. So in a car example, the car is worth 50,000. I want to go on a lease for 36 months, for example. What the lessor, the financial institution does is they estimate the depreciation value. So how much will the car be worth 36 months in the future? It's going to be worth 20,000, for example. So the lessee will pay for the 30,000, the depreciation value. Because after the leasing, I will just return the goods. I will return the car because I was renting it. Okay? And I paid for the value it depreciated within the time period I used the car. Is this clear? Are we okay? All right. So those are some approaches. They are known as traditional approaches, and they are widely used in commercial lives, in our business lives, also personal lives. We now look at the Personal Property Security Act. It is widely known as PPSA. PPSA is an act that has created a scheme, a process for registering collaterals, securities. Because one thing is to offer the real property or the personal property as security. The other thing is to make this effective. It is effective under the PPSA if this collateral or security is registered. The pledge the traditional approach, the pledge, as I told you, when you go to the pawn shop, you give possession to the pawn shop owner of your jewelry. So that is effective, because if you don't repay, the pawn shop already has possession of your goods. They don't need to go and seize them. But in business, the government developed this PPSA so that companies may offer either their personal or real property as security, but keep on using them so that they can make profits, turnover. On the other hand, the creditors, they have effective security because it's registered in a system. So this system, the PPSA, allows creditors, new creditors, to check if any given security was already given as a security for a transaction or not. So that's the PPSA. So it's federal legislation, the same thing all over Canada. And if you have a company, and you are getting a loan from a bank or from wealthy individuals, they may run a search in your company, in your securities, in your assets, under the PPSA to check if you have any assets available to offer as a security. Okay? So the PPSA is this scheme, national scheme. And there are some interesting rules and issues with this one. With the PPSA, other forms of security may be offered, such as you see there, licenses. Let's say I have a license of McDonald's trademark in Brazil. Would you agree this license is worth some money? If I have an exclusive license for the trademark in Brazil, it's worth some money. So I can offer this license to a financial institution to get a loan. I offer as a security. Okay? If I don't repay the loan, financial institution will get the license to themselves and they will sell. So here in Canada, the PPSA allows licenses to be offered as security. Also shares, bonds. So besides the traditional approach, mechanisms, under the PPSA, we have other possibilities to offer as security. Clear? How is this secured relationship created? First of all, a written agreement is required. Okay? So the secured, they are called secured creditor, the financial institution, and the secured debtor, they will enter into a writing agreement. Okay? Loan transaction, and in this security agreement, it is the debtor is saying, I'm offering this asset, shares, books of debts, licenses, trademarks, patents, as security. Right? So that's the first step. Second step is attaching the security. So mentioning in the agreement what the specific collateral or security is. Collateral or security, in other words, they are assets that are being offered to secure the transaction. Okay? They could be real property or personal property. And then, this agreement or this transaction, legally speaking, we say they have to be perfected. What is a loan transaction or a transaction under the PPSA perfected? How it is perfected? It is perfected in one of the two ways. It is either registered in the system, the PPSA system, and you can just Google PPSA search. There will be several companies offering this service, searching under the search under the PPSA. Or the collateral is given to the debtor. But when collateral is given to the debtor, it resembles more the traditional approach than the PPSA. But it also allows perfection. So perfection is making this transaction enforceable, fully enforceable, fully complete. So first, the agreement between the parties, secured debtor, secured creditors. Second, attaching the collateral, bringing the collateral, the asset, the security to the transaction. Third, perfecting it by either registering in the system or giving possession to the debt, to the creditor. Clear? And it's very common. And then, once this transaction is perfected, the secured creditor will have a preference of payment if the business goes bankrupt. So that's one of the main goals of the PPSA, of securing a transaction. And I say one of the main goals because one is getting the title of the security, sell it, or having a priority. But a priority only exists if there are two or more secured creditors in the same asset. Because if there's only one, we don't talk about priority. This secured creditor will seize the collateral, will sell and recover the loss. But if there's two or more secured creditors in the same asset, let's say a big warehouse, big land, so it is worth for a big amount of money in a loan transaction. So the business initially took one loan, offered this warehouse as security, but then was going to get another loan and offered the same security because the security, the warehouse, is worth a lot of money. And the second secured creditor accepts to this. So when there's two or more, the first to register will have a priority over that collateral. So in this warehouse example, let's say last year there was one secured creditor. Let's say RBC, just for an example. This year another loan transaction, and now it's TD Bank. TD Bank probably charges a higher interest because their risk is higher, because they are second in line of preference. If the business defaults, first RBC will have the priority. And then after they are paid out, they recover their loss, then TD Bank can try to recover their loss with the same asset. Right? So that's why this mechanism, PPSA mechanism, exists. What else? So I've been talking about this, but just to emphasize, what are the remedies under the PPSA? And the remedies are mostly related to a loan, a repayment being defaulted. So possession will be taken by the creditor, and then the creditor will sell the security to recover losses. This is true for all secured loan transactions, any types. What I'm going to say to you now is true for all types of secured loan transactions. Whenever the security is seized and sold, they have to be sold by commercially reasonable value, and if there's still a balance owing to the creditor, the debtor still owns that amount. So I leased the car for $50,000. Car was offered as a security. I defaulted payment. I defaulted payment 3 months later. Would you agree that the car, the brand new car that was worth $50,000, because I've used it for 3 months, is already worth $40,000 or $35,000, probably. And I only paid for 3 months, and then I started defaulting. So I may owe the bank more than the car is worth, right? I may. Mostly in a financing, not in a lease. So the bank will seize the goods, take possession of the goods, sell for 35. Oh, if anyone is calling me, just tell them I'm busy delivering the lecture now. So, the car, 50. I got a financing for 50,000. It's worth now 35. The bank sells for 35. I still owe the bank 15,000 or 10,000. And I have to try to pay it with my other assets. But the bank has no security over this balance, just on the car. But what if I finance the car and then I just defaulted in the last 3 payments? Would you agree that the car is worth more than I owe the bank? So the bank may seize the car again, sell the car, but there will be a surplus. This surplus has to be given to the debtor. Okay? So it's true for all type of secured transactions. Are we good so far? And those are all the remedies. And they may be used at the discretion of the creditor. So the creditor, in the event of default, may claim the contractual remedies, or seize the security and then sell the security, or instead of doing this, if the creditor believes the debtor has a lot of assets, a lot of money, they may just decide to sue them for breach of agreement, okay, and get the damages. Look at this question. E, yes. No one goes to prison for defaulting a loan transaction. Okay? In some countries, I'm not sure here in Canada, and I apologize for that, but that's a family issue. In some countries, defaulting on paying support payments is the reason to be arrested. But there's a limit for this arresting, and it's a way to pressure the debtor in this case. So E is the correct one. Moving on, when you don't have a security to offer, your creditor may require someone to guarantee the transaction. So going back to my first example, my neighbor wants 10,000 from me, has no security to offer. But I know my neighbor's relative has a lot of assets, is a rich person. So I may just offer the 10,000 in exchange of the promise, which I have very little guarantee, or I may say to my neighbor, hey, yes, I'll give you the 10,000 as a loan, but I need your relative to guarantee this transaction. Sign as a guarantor. How does this work? The neighbor's relative will guarantee, and the neighbor's relative will have to pay just in case the neighbor defaults. If the neighbor never defaults repayment of the loan, the relative is free. So that's how the guarantee works. I think I mentioned a little bit of this to you when we talked about capacity. Capacity of minors. I told you my daughter would go to a gym. She's a minor. Because the gym knows they are not bound by the agreement, the gym would say, hey, you need to bring your parents to guarantee this agreement. That's the same process. But in that case, the gym was guaranteeing that the agreement would be binding. Here, in this case, the creditor is guaranteeing repayment of the loan with someone else. Okay? So someone else is saying, okay, if the debtor doesn't pay, if the debtor defaults, I will pay. So that's a guarantee. Okay? This guarantee has to be in writing, and because it's a contract, all elements of a contract have to be present. What is important is, if you are ever, between quotations, invited to be a guarantor for a relative or for a friend. Note that one of your rights is not to have your position weakened. The same example, I'm lending 10,000 to my neighbor, and my neighbor's relative is a guarantor. I cannot advance more money on the top of 10,000 to my neighbor without the guarantor's consent. If I do this, I would be weakening the position of the guarantor. The guarantor would have to pay even more. So if you're ever a guarantor, be assured that your position will not be weakened. You will not be liable more money without your consent. Okay? Because if this takes place, you are released from your guarantee. You are not a guarantor anymore. Question?
In your last slide, you said that with a guarantor, there has to be consideration.
Mm-hmm.
What
Yeah.
consideration would the guarantor receive?
This is a good question, because there wouldn't be a proper benefit, express benefit. What creditors would do, they would just describe in the agreement, state in the agreement, in consideration of the following transaction. So just a description would suffice as consideration. But on the other aspect, if we look at the real world, I may be pleasing, I may be helping someone that needs. This may be a benefit. Okay? But that's a difficult issue to be challenged. Courts already understand that in a guarantee, if you are a guarantor and you are signing on it, you know that you may be benefiting the one that is getting the money. And you are actually not getting a tangible or proper benefit out of it. So the agreement will usually say, just say, in consideration thereof, parties agree upon this guarantee and so forth. Okay? So that's an interesting question. Did I kind of answer your question? Yeah, there isn't such a firm answer to this, but that's an important element of the agreement. So, the guarantor cannot have its position weakened. If it's weakened, then they are released. If my neighbor offered two types of security, let's say my neighbor offered their lawn mower plus a guarantor. As a creditor, if I release one of the securities, let's say the lawn mower, okay, I won't take your lawn mower anymore. The guarantor is also released. So when there's one more security offered besides the guarantee, and that guarantee is released by the creditor for whatever reasons, the guarantor is also released from their obligations. Okay? Is this clear? My neighbor is getting the 10,000 from me. My neighbor said, okay, I can offer you my lawn mower, but it's worth $500, plus the guarantor, my rich relative. And then time goes by, and I say, okay, you know what, your lawn mower, I don't need this anymore as a guarantee. For whatever reason, say, no, I don't want this as a guarantee anymore. Because I'm releasing one security, it automatically releases the guarantor's obligations. So I should not do this. Okay? Because if I do this, I lose all guarantees. But there's one type of guarantee that is known as continuing guarantee. And banks, they will most often use this continuing guarantee. As a guarantor, if you agree upon a continuing guarantee, you are agreeing to have your position weakened without giving your consent. So if you're signing a guarantee as a guarantor, make sure you are not, or at least you are aware, you are signing a continuing guarantee. Because in this example, in this scenario, your position could be weakened. So the creditor could give even more money to the debtor that the guarantor would not be released. Okay? That's what a continuing guarantee is. So it brings more risks to the guarantor. Some other forms of security. So we talked about personal property, real property. We talked under the PPSA, we talked about licenses, bonds, shares. But we have the Bank Act. And through this act, other things may be offered as security, such as growing crops, inventories. So I have inventory for my company because I buy and resell the product. I can offer the inventory as security. Goods to be manufactured and so forth. So those other forms, one is the floating charge. This is interesting. Why? A good example is, let's say I am Amazon, I need to get money, and I have a lot of products stored to be sold. So I can offer those products that are mine as security. But because I offer them as security, because actually it is a floating charge, it doesn't mean I cannot sell them. It is floating charge because my inventory is changing. I'm buying and selling, buying and selling. So I have my inventory offered as a security, but not that amount of inventory of that day. It's the inventory that is secured. And I am free to sell them. And then the financial institution is aware that I'll be selling my inventory that is secured, but I'm also getting more inventory. So it does not affect my business dealings. But if I default, the financial institution will come to my warehouses and they will seize whatever inventory I have there. Okay? There's a little higher risk in this one because I may intentionally sell all my inventory and then default repayment of the loan. And then when the financial institution comes to seize the inventory, I have none anymore because I decided not to purchase more. But this is common. Companies will do this regularly. Many manufacturers. So manufacturers, they are manufacturing goods. They have inventory. They also have inventory of raw material they purchased. So they can also offer them. Because inventory, as you know well, they have a value. So this value can be offered as a security. And they are offered in a floating charge security. The buyers, they are not affected by this security. So if I buy any product from Amazon, in my example, I am not bound by that security. The security is just related to the current inventory the business has. Clear? So that's the floating charge. The builders, how do you say this? Liens? Lines? Liens. The builder's liens. This is specific for construction. So, I'm building my own house. I don't have enough money, so I can get credit from suppliers of construction materials, from the construction company, from the workers. I can get credit. Those stakeholders, those players, they may have a builder's liens in the title of my property. So we just learned that all properties, they have a title, right? It's the ownership. It's the document that proves ownership. So they can place a restriction. They can place a builder's liens in the title, saying that I, the owner of the property, own then money. So let's say I owe the construction company $200,000. So the construction company may have a builder's lien in my title. If I attempt to sell my property, the buyer, by searching the title for the due diligence, they will see that I have a debt of $200,000 with the construction company, for example. What is important here is that only suppliers of goods and services, contractors, subcontractors, and workers are entitled to this builder's liens. Okay? Only those players can have those builder's liens. So, the builder's liens is there for, let's say, $500,000. Because I now have a restriction in my title, and I want this restriction to be lifted, to be taken out, the law says I can hold back 10% of my debt, so I pay $550,000 of my debt, but I hold back 10%, $50,000, so that I force those players or any of the players that have put the builder's liens there to take it out, to remove. And then once they remove, I pay the remaining 10%. So they have a good bargaining tool with the builder's liens, and I have a good tool with the holdback. So when I have repaid almost all the debt, I can keep the 10% just to force them to take it out. Once they show me they have taken the builder's liens out from the title, then I pay the 50%. Clear? Negotiable instruments. And the most common ones, they are the promissory notes, bill of exchanges, and post-dated checks. A check may be cashed instantly. So you write a check to me, I may go to the bank and deposit it or cash it out. So it's not a negotiable instrument. It is a negotiable instrument, but it is not a credit instrument because it's payment at sight, almost at sight. It's not cash, but it's at sight. However, when you post-date a check, you have a credit instrument because you are paying for something, but with a term, with a credit term. I will be only able to cash it out or deposit it in the pre-dated, pre-agreed upon date. So that's why they are also used in credit transactions. We also have the letter of credits. So letter of credit, widely used in international transactions, can also be used in domestic ones, but mostly in international transactions. What is a letter of credit? So I'll start buying products from the Philippines. The supplier doesn't know my company. I don't know the supplier well. So I don't want to pay in advance, but the supplier doesn't want to start manufacturing my goods without my payment, or at least partial payment. They will be at risk, they will be investing raw material, etc. So a letter of credit could be used. It has costs. But with a letter of credit, I, the buyer, speak with my bank and say, hey, can you issue a letter of credit? In other words, can you issue a declaration in which you honor the payment of this purchase if I default, if I don't pay? You, the bank, that know my company well, can you issue a letter of credit to my supplier? So with a letter of credit, the supplier is assured that upon some conditions, such as finishing manufacturing the goods or boarding the goods, so the buyer can place a lot of restrictions in the letter of credit if both parties agree. But then the bank that knows my company will honor, or at least state that they will honor the transaction. if I don't pay for the transaction. And this is a service from the bank, from my bank. So there's cost to this. Okay? But it offers some security for both parties. I am not paying in advance, but I am also showing that I may have funds or my bank may honor the payment in case I don't. Is this clear? Are we good? Okay, so I told you it would be a bit boring, or more boring than usual. So what I'm going to do now is bankruptcy, very interesting subject. But if you agree with me, I can just move on bankruptcy, or we can stop for 10 minutes, and I can record a video on bankruptcy. What do you prefer? You want to go for a break or break? Yes, so this part I will be recording, okay? And making them available to you. After the break, we'll go for chapter 16.